We are speaking today with Tiffany Cianci, who is a mom, previously a professional sommelier, and now an ex-owner of The Little Gym franchise. And Tiffany's been in the press quite a bit lately, was recently featured in a New York Times article that was entitled When Private Equity Came for the Toddler Gyms. Tiffany's franchise experience has been far from pleasant. As you will hear in a moment, her legal costs defending against this franchisor have soared into the hundreds of thousands of dollars, for which Tiffany has nothing to show for, as corporate has terminated her franchise contract. And these private equity takeovers are happening with greater frequency. So if you are a prospective franchise buyer or someday intend on acquiring a franchise, you will definitely want to hear this cautionary tale. As always, the opinions of guests are welcomed. We offer an equal platform to both franchise companies and franchisees to share their side of the story. And thank you very much to our viewers for watching and leaving comments. This greatly helps us get these messages out to more people. The link is in the description box for Tiffany's GoFundMe to help with ongoing legal costs.
Tiffany, welcome to the show.
Thank you for having me.
Great.
I'm really excited to be here.
Yeah, great to have you on. And thanks so much for sharing this cautionary tale with us today. And I know it's not easy given the circumstances, and we'll discuss those today. So why don't we start right at the beginning? You bought The Little Gym franchise back in 2017. Can you tell us a bit about why you chose this franchise and what your initial experience was like with them?
Yeah, so my oldest daughter is 21, but when she was little, she had a serious kidney issue. She needed 2 kidney reimplantation surgeries, and she had a port, and we couldn't find any classes that would allow her to participate. So when she was very little, we attended The Little Gym. When I was further along in life and I was looking to make a transition to owning my own business, there was one for sale in my community, and that seemed like a good choice because I had a degree in music and a degree in dance. And I thought, I could do this. This would be great. I could bring my younger kids to work with me. That's what the big pitch was. It was family oriented. It was, choose your own adventure, and we're going to work with your family's needs. And we want to see how you fit into our big corporate puzzle. And so it made a lot of sense for where I was in life and what I wanted for my family dynamics to take that step.
Great. And initially things were, okay, corporate was supporting you.
Yeah, we like any resale, there's always hiccups and bumps and things you don't expect when you're doing a resale of a franchise. It's not
I've
quite
seen some horror
easy as
stories. Yeah.
like when you do your own build out, maybe it's a little bit easier. But I can definitely say that over my 5 years, there was a general understanding in our franchise that the corporate office wanted what was best for the franchisees, and they
Right.
cared about the brand and they cared about the kids. That was really important, and they really put the kids first.
Right. Very important,
believe that.
obviously, in this type of environment. And that's, yeah, not to get off topic, that's one of the things we tell people when you buy a resale business, there can be some hidden baggage that you don't know about. So yeah, always something that there's going to be some unknowns, always something people have to consider. Absolutely.
Yeah.
So ultimately, the franchise entire company, the system was sold to an equity group. And this
Yes.
allegedly was when these problems started. How was that presented to you? How did you find out that the franchise had been sold?
It was pretty horrific, if I'm being honest. First of all, they were introduced to us as strategic marketing partners. They weren't introduced to us as our new owners. That was left out of the conversation initially. We were excited because we were coming out of COVID, and all children's businesses suffered during COVID, some of us more than others. I was closed for 17 months in my county.
Wow.
And so we were excited to have this big new marketing announcement. We all logged on for this big new marketing partnership announcement, only to see a bunch of red eyes in the room and everybody crying to find out somebody comes on and says, we have fired the board, and your CEO who's been here for 30 years is gone, and your COO is gone, and your CFO is gone. And then this gentleman, Michael Browning, comes in and says, I'm your new CEO. Welcome to the new Little Gym. And you have to understand that for a brand that the average length of time I think somebody was at our corporate office was more than 20 years. They'd been there forever. They understood the brand. They understood the why. They understood our 3 axioms about how we teach children. And they understood that we always put the kids first. And to see such a dramatic announcement with all of us on a system-wide phone call was shocking, to say the least.
Yeah,
We tried to, be hopeful, but it was shocking.
Right, right. So not a great first impression out of the gate.
It was
But
tough.
you try and go with the flow. You overlook these things. Maybe it's a one-off, but seems to be it wasn't a one-off. So after that takeover, you're saying that things really went downhill. There were these substantial changes that were implemented by Unleashed Brands. They were quickly implemented. Let us know about some of those changes that you experienced that you weren't very fond of.
Based on what I've learned since all of this took place, it seems like whenever a new ownership comes in, they have all the big aspirational plans that are presented. And I've got to be honest, Unleashed Brands said all the right things and did all the right things to give us a little hope that the changes they wanted to make were not the kinds of changes that would change us fundamentally as a brand. They said that they wanted our culture, that the Little Gym had been successful for 46 years and they were a brand new company, and they wanted to learn how that culture did what it did for our company, and they wanted us to come in and share that with them, and that what they were going to give us were technological advances. They were going to streamline our hiring processes. They were going to give us support in training, the things that were hardest to do, because we are a service. We're not a product we sell, right? We sell service. And so labor is our biggest cost. And so they said the right things. They led us to believe that we were going to get updated computer systems, that were going to take into account all of our existing computer systems, that it was going to streamline so parents could get an app, which we'd been asking for a long time and our competition had. But that's not what followed. The first really bad sign, like our huge red flag, was that we started getting phone calls over spring break in 2021 from our corporate office. And they would call and they would say, just checking if you're answering, and hang up. Now, our corporate office had us close on spring break. Generally, we would be open very little because people travel, they don't come to classes. So those were usually our breaks each year to clean our gyms, to reset. But they called over and over and over and over again, and we were closed. People started forwarding their phones to their cell phones because we were scared about why they were calling. And it quickly came to light. It's because they were doing a survey to see how often we answered the phone within 14 seconds. And nobody was open. They specifically chose a week when we were closed for spring break across the country. And so what happened was 3 weeks later, we got on a system-wide call and they said, based on a comprehensive data analysis, your customer service is seriously lacking. We'd had one of the highest net promoter scores in the country for our division for a decade. Okay. And they said, your customer service is lacking. So we're here to introduce your new call center. And your new call center is going to help alleviate the strain on your front desk. Parents are going to be routed to a call center and we'll take it from there. And we were like, well, what's that going to cost us? That's never been conceived of in our franchise agreement. What's that going to look like for us? And they said, oh, details coming, details coming, details coming. So they introduced it and it kind of went away for a minute. But we were all pretty nervous because nobody wants to talk to a call center about their 15-month-old child that maybe is having physical delays, and they want to know the best class for them. They want to know which teacher is best attuned to their child on the spectrum. And nobody at a call center could know that about our specific locations. So the technological advances we were hoping for, like an app or a streamlined communication system, ended up being a step backwards to like the 1990s and a call center.
Right.
But what it did do was it created a new revenue stream for our corporate office, because it was going to ask us to pay for things that were never conceived of in our franchise agreement. Right. And it was going to require it in a really, I'm just going to say, kind of a nefarious way. We were then, after they mentioned the call center, provided a new payment method in November of 2021. They gave us a new ACH agreement. That seemed reasonable. Our franchise agreement said that they could take our advertising fees. Well, it didn't say advertising specifically. Our tech fees and our royalty fees via means could be required. It says that in our franchise agreement. I agree with that. I signed that contract. They presented us a new ACH agreement and said, you need to sign this. We're only going to use it for tech fees. And that was what it said, only for tech fees. But that's not what the contract said. The contract said we can take any sum for any reason at any time to pay our company, parents, subsidiaries, affiliates, vendors. They could take any amount they wanted, and that was not what our franchise agreement said. As a matter of fact, it was a vast expansion of what our franchise agreement said. I got nervous about that because I had read that the Urban Air franchisees had filed a class action lawsuit against Unleashed Brands. They were the first franchise.
Yep.
And at the heart of that class action lawsuit were two documents. One was an ACH agreement that vastly expanded the amounts their corporate office was taking out of their accounts monthly. And the second was a marketing initiative that had something to do with a call center. And so I was very hesitant. I sought the advice of an attorney, and he said, you cannot sign this. This is changing your franchise agreement. And your franchise agreement, all of your franchise agreements that I've seen, have a specific clause that says no changes may be made to this agreement except by the express written permission of the party so bound. If you sign this, you are giving them permission to change your franchise agreement. You cannot. And so I took that advice very seriously, especially because it came from an attorney that had worked with our old company at some point in his past and had seen those franchise agreements in some situation. And I took that very seriously. So I set about contacting them. I said, listen, I'll sign any ACH agreement you give me that complies to my franchise agreement. As long as it complies with that language, I will sign it. I will pay you any electronic way you want, as long as it complies with my franchise agreement. I'm open to that because you bought my contract. I didn't marry you. You married us. And that was not acceptable at all. It turned out that there were lots of people that were hesitant about that agreement. The pressure came on swiftly. Again, they had said it was only for tech fees, for tech fees. And everybody had it due at some point in November. It was within the few days after the cutoff to send back the ACH when most franchisees who had always trusted our corporate office just signed it and sent it back thinking that's what it was, that they announced it was now for royalties too, and that it would be expanded to include other things like marketing fees and things that come down the road. Right. Literally minutes after everybody signed it, just in those immediate days. Those next few weeks after that, they announced that the call center was moving forward and that would also be included in the ACH agreement. And then it got really kind of dark, if I'm being honest. They formed a pilot group. The pilot group were the ones that were going to test the call center. They called these, I think it was 8 owners to a meeting. And they said, you're all ready. You're all in the system to go. You have to sign this agreement while you're on this call. And they said, we need to go see a lawyer, right? Like, we've got to go see a lawyer. No, you need to sign it while you're here. And this new agreement was not simple. It was not easy to understand. As a matter of fact, it was built kind of like a Hobson's choice. That next email said you could opt in or opt out of the call center. However, anyone in the pilot group that had been specially selected for the new committee to get close to the corporate office and, have a say in things, if they didn't sign it, they were out. Their committee and pilot group participation was cut, and that was a threat. You'll sign it or you're out.
Right.
And when people ask questions like, well, what if I change my mind? Or what if this doesn't work? This document says that it's forever. It says the rest of my franchise agreement. He said, oh, don't worry. You can opt in. You can always opt out later. But that's not how contracts work.
Right.
They didn't have any lawyers on the phone. They weren't getting to go talk to a lawyer. And so this document said you could opt in or opt out of the call center. The problem was, if you opt in, you're agreeing to a bunch of new fees that are not allowed by your franchise agreement. And if you opt out, it says in small print, by choosing to opt out, you're agreeing to run a professional call center that complies with all of the specifications we've laid out for our call center. You're agreeing to give us access to all of your phone lines, to hear all of your phone calls, to access all of your recordings, but they give no details about how you could comply with their technology. Like, there's no bridge software offered, there's no specifications. And they say, and if you don't, then you'd be in default. And,
right.
That could lead to termination. And at the end of all of it, no matter if you choose opt-in or opt-out, the entire document, no matter which way you sign it, permanently changes your franchise agreement to include these expectations. So no matter what you choose, you are agreeing to change your franchise agreement.
Right.
Forever. And that's not allowed by our franchise agreement. That's a scary document.
Yeah.
And it's not a great way to start a relationship or build trust.
You would think.
And so I started hosting these calls saying, guys, I think that I just want to share with you the legal advice I was given. I'm not a lawyer. I can't give you legal advice, but I will give you what I paid for. You can see what they're telling me. And I'm just going to tell you that I would not sign this contract if I were you. And it's up to you guys to go seek that counsel and see if you want to. Those late night calls turned into letters of expectation we were being given for not complying with the call center. And they turned into threats of termination. And then we formed a franchise association that I was the president of.
Right. Right. Lots of fun, for sure. Now, you speak to termination. One of the things, if I'm not mistaken, that was ushered into the new agreement or somewhere was this clause, they call it liquidated damages, whatever the case may be, that if you are in fact terminated, there are some financial penalties for franchisees. So, these sort of, and this is, just speaking out loud here, these at least perceived as draconian implementation of all of these new terms. If you don't agree to them, you get terminated. And if you get terminated, you owe a certain amount of money, correct? And
Significant amount of money.
right. What did that look like? How much do you owe if they decide to terminate you?
So I will say that this came into the operations manual, which they rolled out shortly after my termination. But the way that I understand it, it is $100,000, or I think it's 3%, or 36 months of whatever your average royalties would have been, whichever is greater. So it's like anywhere from 100,000 for a low producing gym to 300 or 400,000 for the top producing gyms if they're terminated. And it was put into an operations manual that they don't have to sign for, that they don't have to agree to, that was not conceived of. That's what it says. That same operations manual also said that our owners weren't owners anymore. Even if they'd owned for 30 years, they were now a strategic partner, and they didn't have the right to call themselves an owner of their independently owned and operated business.
Right. Right. So, to add insult to injury, not only do you get terminated, you're out the door. By the way, give us minimum $100,000. That makes it, a lot easier to start terminating people. It's a revenue stream, right?
Exactly. It actually encourages that revenue generation. And it's also a great way to send a message if you have to make those choices, or if they make those choices.
Yeah. Yeah. And a lot of people, obviously they get scared, right? I mean, geez, it looks like they are holding all the cards at
Exactly.
corporate, right? And, I've heard, anonymously from, I couldn't even count how many people who've gone through similar situations, and, they just, due to the gag orders, NDAs, whatever else, they don't want to speak up. So yeah, again, appreciate what you're doing under, a lot of pressure, but the message is getting out. And I think that tide is changing. That pendulum is switching back over to at least give franchisees in some of these systems a little bit more power. Wanted to speak as well to, as I understand, the brand also wanted to make some changes to the employee situation. Can you speak to that? What did that look like? And in my opinion, this type of business, your employees are kind of the foundation of the business. You want somebody, dealing with kids who is competent and, good at what they do. What did that look like, those changes that they wanted to implement?
So they changed a couple of things. First of all, they capped how much we could spend on labor. In the new operations manual, which again, not part of the franchise agreement, not conceived of for many of these people that had owned for years, but they capped labor, I think at 30% in the new operations manual, which meant you had to cut costs or you would be found in default. I have heard from 4 franchisees that have been contacted because their labor was too high, even though they were profitable and they'd been running their business the way they always had, in a profitable way, that they were told they had to spend less on labor, I think because of its impacts maybe on, I think they called it something like EBITDA. But what happened is they came in, and their first piece of advice to us, the big hiring seminar they gave us when they first arrived, was that we should hire 14 and 15-year-olds the way they encourage people to do at Urban Air. Now, I'm going to be frank. If you search the internet, there are lots of issues with people saying that they've been injured or hurt at trampoline parks all across America. I don't know how that affects them, but I know when I'm holding a 5-month-old baby and flipping them over a bar, and I have been training for years to do that, and I train an instructor for 10 to 15 months before they're allowed to handle someone that small, that the idea of hiring a 14 or a 15-year-old to cut our labor expenses and hand them a 5-month-old baby is not tenable, and illegal in some places, by the way. But that was the advice we were given. We were also told to cut down under the new operations manual. I think a week is the requirements for training. Like, you have to train at least a week, but for the average little gym owner, we trained people for months before we saw a return on $1 of our investment. They have to learn to spot. They have to learn to safely engage in a gym environment and to keep an eye on all of the kids around them. They have to learn how to safely touch children in a way that's appropriate. They have to, there's a minimum number of things. And then there's CPR training and first aid training you have to have. So the idea of cutting things in that way, safety first has always been a rule for the little gym. We say it in every class, and that did not feel like we were putting safety first.
Right. Yeah, it looks more like profit first, in my opinion. Anyway, so we have a lot of these obviously very significant changes. As I understand, and as corporate will disagree with, but there was a substantial number of franchisees who disagreed with these things. As I understand, 90% of owners eventually
Right.
got involved into this group, and ultimately you were this franchisee group, ultimately of which you were elected president. So you guys are out trying to level the playing field, just trying to, get some information out to corporate that, hey, can we just slow down? Can we discuss these things? What happened then?
So 93% of our franchisees in North America, even the Canadians who are not impacted by these changes because of the laws that protect them up there, 93% of our North American franchisees joined the association. From our research and from what we've been told by legislators, that is the highest number anyone has ever recorded in a franchise association that doesn't have an automatic corporate opt-in. It seems to closely follow Jack in the Box, which I think got to 86% before they were able to successfully oust their CEO and call for a vote of no confidence in their franchise, their franchisor. And so we had a very high participation rate. There came a point in April and May of 2022 where we sort of reached a fever pitch. We were being sent letters of expectation saying we were going to be defaulted if we didn't start to fall in line with these new amendments to our contract that were not allowed by our contracts. And the threats came very swiftly. In April, I was provided a formal default notice for refusal to sign the ACH as written, which I responded repeatedly I would be happy to sign if they would be willing to negotiate or mediate with me on the language to comply with my franchise agreement. I was the first default notice that was sent out. And then in May, we hired an attorney after the letters of expectation got worse and were threatening. And that attorney crafted a cease and desist letter that was not meant to be mean-spirited. It literally said, we want to enact the mediation clause in our franchise agreement. We've always had lines of communication that were open with our franchisor in the past. We would like to build a mutually respectful relationship, but we need to start with mediation to talk about why we don't agree with what you're asking of us and why we don't feel like it's good for our businesses or practical or financially responsible for our businesses. And the response was swift. We know based on court filings, evidence, and their admissions that as of May 18th, they were calling lawyers, asking who was sending a letter. They'd heard whispers of this letter coming from this franchise association. They were calling law firms around the US saying, we know this letter's coming. We know this letter's coming. Is it you? Is it you? Is it you? That was the chief legal officer making those calls. And then we know on the 19th that the letter went out. We received warning from law firms that we needed to hurry up and that the letter needed to go out. That same day on the 19th, there was a flurry of 7 minutes of emails back and forth between some folks who decided that it was time to terminate me based on my terrible payment history, 7 minutes, and referenced payments that I had missed when we were closed for COVID and in deferment for all of our payments, coupled with the payments that I had been sending via check because they would not work with me on the ACH agreement, that they were not cashing. And 1 hour before they got the letter, they sent an email saying, time to shut her down. And then they got the letter at, I think, 6:08 p.m. that night, but we're very aware of the Franchise Association before that, clearly, or they wouldn't have been calling law firms. And they had also engaged with Facebook posts about it earlier in the week, senior people at corporate. And on the 20th, I lost my franchise.
Wow, that's crazy. And, just for the folks watching, it's not allowed to do a retaliatory elimination of someone. But Unleashed is suggesting that this was not retaliatory at all.
Sure.
That this wasn't. No, it had nothing to do with the fact that you aren't agreeing to every term that we put forth to you, or that you're kind of stirring the bee's nest up. Nothing to do with that at all. Nothing.
Yeah. For the record, all of our franchisees were provided deferments during COVID. At the time that in April, the payments that they've tried to say that I wasn't making, I didn't reopen until July of 2022 for regular in-gym classes because my county had one of the longest lockdowns in the US. And I was communicating with corporate. I told them every step of the way that, we're not open yet. Please give me advice. Tell me what you want me to do when we want to restart. They told us they would give us payment plans. At the time that those communications took place, there were dozens of high-performing gyms that had reopened that hadn't started repaying yet. I took out a loan and did my best to pay back everything in one lump sum. Unleashed Brands was aware I was taking out an SBA loan. They encouraged me to take out that loan to pay everything back. They took my payments all the way up until February of 2022 and I paid everything in these 2 big chunks. And at that time I was sending them checks and begging for an ACH agreement that would comply, begging, literally, and saying, please give me anything I can sign that works with my franchise agreement, please. I would like to pay you electronically. I would like to comply. They did have my payments. And then in my termination letter, there's actually a line that, and I'm gonna quote this approximately because I don't have it in front of me, that says, we think you're likely to default this month on your payment because you haven't signed the ACH. I wasn't late. Payments weren't even due or considered delinquent at the time of my termination, but they later cited that month and said that that was one of the reasons. And it's also come to light that they have never terminated anyone else for non-payment, ever.
Right.
Ever.
Right.
Like, we can't find a single instance in the history of the company where someone has been terminated for non-payment, and certainly not someone that they're claiming owes no money and is totally current on payments.
Right. Right. So
Yeah.
something quite possibly not right there. One of the things that you mentioned was a similar lawsuit with another brand. Was it Urban Air?
Urban Air, yeah.
Okay. Is it accurate to your knowledge that I think, is it 4 of the other 6 brands under Unleashed are currently in or have been involved in similar types of lawsuits? And I think all of them have been brought about by franchisees, if I'm not mistaken. And I know you've done a ton of research, obviously, after the fact.
Right.
Does that sound accurate? That
It was
a lot of these
reported by
similar
the
lawsuits-
press. It was reported by the press. So I know Urban Air has filed a class action lawsuit and arbitrations. We know that Premier Martial Arts has filed a RICO class action against them for fraudulent practices. We know that the Little Gym and myself obviously have all retained counsel at this point. More than 90% of owners are represented by counsel at the Little Gym at this point. And based on reporting in the press this week, the same as Snapology formed an association and recently hired counsel. And apparently Class 101 has as well. I don't know any of them personally, but it says in the press articles this week that it was confirmed that they are seeking to take action.
Right. Right. And at this point, obviously, you were recently in the New York Times, been getting a lot of press, working with members of Congress to hopefully make some changes to these one-sided laws. How's that going? And what do you have in the near horizon?
So right now we're working we're trying to work in a very bipartisan way in Arizona to start. The Arizona legislature is where we chose to begin because all Little Gym contracts are held under Arizona law, or at least all that were at the time of the acquisition are held under Arizona law as the form of choice in our contracts. That gives them a leg up, obviously, because they can afford to fight anywhere, but franchisees, we have to pay to fight all across the country. And there are very few lawyers available in Arizona, by the way, that practice franchise law. Yeah. Most of them are conflicted out. So it's very hard to find counsel to represent you. But we started in Arizona because one of the other really difficult cases of franchise retaliation and franchise litigation also took place there, and that was Cold Stone. And so Arizona kind of has this dark umbrella of franchisees needing support over it. And it's a state that had no protections on the books whatsoever for franchisees, even looking at something as simple as making sure that people aren't defrauded via fraudulent FDD reporting. There's no mechanisms in place for a franchisee to seek assistance in Arizona, which is creating a chilling effect for franchisees that are seeking to enforce their rights, afraid to go there and try to take action. So we want to make sure that we started somewhere where it would protect the Little Gym franchisees first, and other franchisees based in Arizona or who have contracts based in Arizona or governed by Arizona. And then we're seeking to expand that. Now, there's currently 19 states with laws on the books of some kind as of last year. But Arizona, we were very proud to say, cleared the Commerce Committee last week with a 9-1 vote when we were told it was dead on arrival on a partisan split. They listened to the franchisees that turned up. The Republicans clearly heard their plight. The Democrats asked great questions in the room, and they let us speak for a very lengthy time on a night when they had 19 bills. I will be forever grateful for the amount of consideration the Republican Party has been giving in Arizona, because they have 19,100 franchisees across their state, 9% of their GDP. And I'm hoping that we can see this through. We're headed to a floor vote, hopefully this week, and then over to the Senate, where we have broad bipartisan support on the Senate side. And there are a lot of franchisees in the legislature that are seeing themselves be harmed by these situations. So we're really hoping that this is something we can emulate, maybe going to Pennsylvania next, or going to Tennessee where Premier Martial Arts is, and then continuing across the US and hopefully at a federal level as well.
Yeah. And that's great. And it's very admirable on, their behalf. And not only from a time perspective, but also, as you probably know, there's a lot of political pressure coming in that really wants to go in the other direction, right?
Yes.
So yeah, it's good to see that there's some movement in the other direction. How would this ideally, in your opinion, be resolved? Is there an outcome that you're looking for here? What would you like to see?
I'm going to tell you that's the hardest question anybody can ask me. I'm locked in a sealed arbitration. I only get to talk to people because they brought me to court in open court before we went into an arbitration. So I have public documents I'm allowed to share. But these issues that franchisees face always stay behind closed doors, and they all have non-disparagement clauses that can be, pursued after the fact. So these things stay quiet all the time.
Yep.
For me, they did make me a very loose offer of settlement at one point, but my lawyer told me it was predicated on me never advocating for the franchisees again. And it was not, that was way back in the very first weeks that everything was happening. It was also predicated on me signing the amendments to my franchise agreement. But when I look at it now, and they've spent millions of dollars, they're alleging, I think, $200,000 in damages against me for continuing to operate a business that is not competing with them in any way. And there are no little gyms within 25 miles of me, which would be what would allow that. They're not pursuing me for equity. They're pursuing me to send a message to all the other franchisees.
Right.
And it's working. And so for me, I would love to resolve this. I would love for somebody to take notice and for somebody to maybe say, we want to rebuild trust with our franchisees and acknowledge maybe they're doing something wrong when all of their brands are so unhappy. I don't know what the end looks like because you don't get the same kind of equity in arbitration. My contract limits me to real damages only, which means all the defamation they're doing to me doesn't really come with any penalty for them.
Right.
At this point, I'd really like to go back to teaching babies. And I would really like for this to make a difference for other franchisees.
Right.
That would be wonderful for me. There's not like a dollar or a goal at this point. I'm trying to survive in litigation. We are drowning. I have one lawyer, they have 12.
Right.
They have the largest law firm in the United States and we are barely hanging on. I have, I think, $23,000 in fees due this week. We're $300,000 in legal debt.
Wow.
Over for what,
Mm-hmm.
And that's why it works. That's why what they're doing works. That's why it
Yep.
works in sealed arbitrations all the time. So for me, I guess the result is that we get through this mess, this horrible, horrible legal mess, but that I can make a difference for others.
Right.
I think that's where I'm at.
Right. Yeah, it makes sense. And it's a shame to have to go through all that. It really is. I think to most people who would be watching, they would perceive this as very counterintuitive. Coming in, franchise is running okay. It's all good. People are happy. And they just smash everything to bits, change everything around. It really alienate most of the franchisees from the sounds of things. Can you speak to, the motivations, the timelines, why private equity has a lot different mindset and way of thinking than private owners would?
Sure. Now I obviously am not a private equity person, but I can say that I've been doing a lot of research and I've spoken to more than 100 franchisees whose brands have been acquired by private equity in these last few years, because it's been doubling and tripling the last 5 years, acquisition of franchisors.
Yep.
I will say that Mitt Romney, their capital group that went in and saved Domino's, decade and a half ago or whenever, that was a different private equity acquisition style. I believe that there is a possibility that there's a way that private equity acquisitions could make franchising better. I believe that that's a possibility. But the difference is that when they were acquiring Domino's Pizza, their plan was to get their money back and make a return on their investment over the next 10 and 15 years. And that was a long-term investment for them. Current private equity, the goal seems to be quite different. And while it's not spelled out explicitly, the trend you're seeing is that when a franchisor is taken over by a private equity firm, the goal seems to be to flip it every 14 to 24 months. And when Domino's was taken over and they said, we want to get our money back in 10 or 15 years, that meant they had a long-term interest in the long-term success of those individual franchises, because that was the only way that could happen. They needed to elevate the brand as a whole, and rising waters raise all ships, right? But when you're trying to get your money out in 14 to 24 months, well, the average franchisee is paying a very small amount of royalties compared to what you can make on selling a new franchise. Or in the instance of a termination where you get $100,000, or in the instance of somebody getting presented with a renewal contract that is so unpalatable they couldn't possibly sign it because of the new terms, and then you somehow get to buy that back from them for pennies on the dollar and resell it for a huge investment. There is more money to be made in that circumstance on new franchises and terminations than there are in the 14-month or 20 months you're going to get royalties from an individual franchise. There's also more money in splitting up an existing territory into smaller territories and reselling those off for 3 times the amount, right? Which is something that keeps coming up for territories that have existed for a long time, but are now being told they might be split into 3. And so in that circumstance, I think that this is really kind of a convergence where there's a conflict of interest. If your interests are getting the money out in 14 to 24 months, then the long-term success of those franchisees is someone else's problem. And while you hope that the intentions are good, you want the intentions to be good, and you hope that they're trying to pass it to the next person so it's attractive, the only way you can really gauge that is through truth in reporting and FDDs, which is precarious at best, and the long-term success and seeing what plays out. Right now, it's a scary proposition for a lot of franchisees.
No, for sure, for sure. And we're seeing so much more of it, these equity takeovers. I anticipate that we'll be seeing more and more of this, unfortunately, in the future, but hopefully there'll be, more eyeballs on this and more positive changes in that regard. Before we wrap up, any final words that you want to share? Anything you want to say?
I would say if you are in a franchise state that has protections, make sure you read your FDDs carefully, invest carefully. And, I think franchising is still an amazing on-ramp to entrepreneurship in America. And I think everyone has to do their due diligence, but if you're in a state with no protections, you need to do more. Call every franchisee on the list of those FDDs and see what's really going on before you buy. And I would say everybody should take your kids to visit the little gyms, because these franchisees really need your support. If you happen to be in Frederick, Maryland, come visit Teeter Tots, because that's what I do now, and go see a kinder music teacher.
Cool. Thanks for that. And I appreciate you still have some positivity towards franchising. Often people just, put up a wall and all of franchising is terrible, which is not the case. So very good.
No.
Very good. Again, Tiffany, thanks so much for being here. Appreciate you sharing today. Viewers who are interested in following this story, you can subscribe to the channel and we will keep you informed. Thanks for watching.